I'll turn it over to you guys, to you, Ashley.
There we go. How about now? Is that better? Okay, cool. Can you guys all see my screen? Just want to make sure I've got it right. I think everybody's muted. Okay.
I see it.
You guys can see it. Okay, cool. All right, so today we're going to go over some common buyer contract terminations. I know the market's kind of crazy right now, so this may be something you're running into, it may be something you're not, but it's always good to know because when it does change, things change. How many of you guys, or Ashley, you can probably fill me in, is everyone on here relatively new, or are they more? I know obviously Tyree's not. But...
Andre is not.
Okay.
Chelsea and Melissa are seals, so we're relatively new.
Okay, perfect. Very cool. Very cool. Well, it's good to have you guys. So we'll run through some of these. If you have any questions, you can unmute yourself if you want, or you can do it in the chat screen. I'm not really great at monitoring that, but I'll try to do that while I'm going through the slides as well. So let's get started. All right. And I'm using George's computer, so I'm trying to figure it out. Okay, so the first one, and I actually got a call about this one today. It's kind of funny. I knew this was coming up, and I had a buyer's agent call me and ask if they could get out of a contract using this. So your third-party financing addendum has two parts to it. One is the buyer approval and the credit approval through that, and the other is going to be the property approval. We'll talk about the property approval in a second, but this portion right here talks about whether or not the buyer can obtain financing. And so you're going to put a time frame in here, and it's basically going to give your buyer the chance to go to the lender, provide all the documentation they need, meet all the lender requirements with their credit history, their assets, their incomes, things like that, to make sure that they can qualify for this loan. And what we're seeing now, and I'm sure Tyra, you can attest to this, is that we're seeing really short time frames right now that the sellers are giving buyers to approve. So you want to make sure that you're obviously using your preferred lender, and you're making sure you're really good communication with someone constantly about it. We had a situation yesterday where a buyer is buying an $800,000 property. He thought he was pre-approved, and the way his assets, he's got plenty of money, but the way his assets are lined up, the lender's not able to get it done. And now they're 2 weeks past closing. He's got $25,000 down in earnest money, and he's panicking for obvious reasons. And so it's just really important to make sure you're really working with someone. And I know you guys probably have preferred people that you work with, which is great. Just make sure you're in constant communication. You're keeping your buyer in constant communication with the lender. In this situation, they had funds in an IRA and it needed to be in a trust. And they can't pull them out of the IRA and put them in a trust in time. And so they're at risk of losing their $25,000, even though they could probably pay cash for it if they could get the assets moved in time. So it's just really important, I would say, on this particular part of the contract, to stay in constant communication with the lender and make sure everything's good. Have any questions about that? I'll go to the next one. Okay, the next one deals with property approval, and these are often confused. A lot of people call me and they say, hey, we're past the third-party financing addendum and it didn't appraise. What do I do? There's actually two separate approvals in the third-party financing: the buyer itself, which you just talked about, and the property itself. Okay, so the property itself has to approve via appraisal, insurability, and any lender required repairs. And the buyer has no later than 3 days before the closing date to terminate. So you guys could be well past all of your contingencies and your appraisal will be late and get out of the contract very, very late. They have to get a notice of termination, and they have to give a copy of the appraisal, and then the buyer will get their earnest money back if they terminate for this. Are you guys seeing a lot of, I'm sure you probably are, appraisal waivers right now?
Yes, definitely.
Yeah, and so this is not coming into play probably as much. You're really more so looking at the appraisal addendum, which we can talk about if you'd like. I think I have that pulled up also. Because of the way the market is, not a lot of people are getting out for the appraisals, but it's still out there. So just to keep in mind. And then this is the portion of the appraisal addendum, and I'll actually pull up, I have it on my computer, but the appraisal addendum itself. So this is box 3 of the appraisal addendum, and this is where the sales price, basically the appraisal has to come in at a number. And so you guys the buyer's going to pick a number, and if it's not that value, the buyer can terminate under this addendum. Not seeing this one as much, probably. We're probably seeing more of the example one with what's going on, just the number one in the contract where they're gonna pay the difference. But this is out there. You know, this is probably more so in a buyer's market where they're wanting to make sure they're not overpaying for something, and that their property is going to meet a certain number. So some of these, like I said, used to be very prevalent, and right now they're kind of not, but it's good to know as the market shifts, things are going to change. And we'll see when that happens. We've been saying that for a couple of years now, I feel like, and it's still insane. So we'll see what 2023 brings. I think 2022 is still going to be great for the remainder of the year. So your termination option. This is your standard option period. The important things to note in this is when you have to give notice and when you have to get the money to the title company. Now that you're delivering it to us, which has been a really big change for us. You know, I don't know that we love that change, but we're working through it. I'm not on the broker lawyer committee, so I don't get an opinion. But it's cool. You guys get to deliver it. It is a lot easier for you guys not to have to run checks over to the sellers and get them to sign off on things, especially when, you know, the prevalence of these cloud brokerages are popping up and it's kind of hard to get a listing agent to sign off on anything. So, you know, it's probably a good change for the industry as a whole. But just note if you don't deliver the option fee within your time, you do not have an option period. So you can't fall back on it. It won't be, you know, you won't get your earnest money back for that. There are a lot of other outs that we're talking about now. But just make sure you're delivering it within the time required and you're getting the notice of termination by 5 o'clock. Long goes the days of you guys on a Sunday at midnight negotiating repairs, which is nice, I think, also for the industry, because that was kind of a disaster. So just time is of the essence. Strict compliance is required for option. So there's no, if you don't hit that, there's no right to cure like there is under the contract and other terms, if that makes sense. Fixture leases. So this one's kind of interesting. I don't see this, you know, popping up quite a bit, but if there's any fixture leases, I do actually think this is going to start happening more often. Fixture leases like are in terms of solar panels and things like that. You have to receive a copy of the fixture lease. If you haven't, within a certain amount of time, obviously what's written on the screen there, then you can terminate and receive your earnest money back. Have any of you guys sold any properties with solar panels? Tyree, have you sold any?
No, I have not. Not with solar panels already on them. No.
Okay, so solar panels are kind of a pain. So if you're taking a listing or you're on the buy side of something that's going to have solar panels, make sure you're just call me before you put an offer in. Because walking through it, it's actually fairly difficult depending on how the seller financed them. They may be leasing them or they may have financed them. And so if they're leasing them, buyers can move in and take over the lease, which is the easiest way to do it if the buyers want it. If they do not, there's this whole process for having to get them removed and how much the seller still owes, and it can become super complicated. I don't see a ton of solar panels, but at the same time, I think we have a lot of people that are moving here from other states that are probably used to that form of energy. And so I think we're going to start seeing them pop up more and more frequently. But just note that if there is solar panels on a lease that you guys are taking, you have to get a copy of, or on a listing you're taking, you have to get a copy of the lease or figure out what they did to get those solar panels installed. Because there is a time frame that the buyers can back out if you don't get that paperwork to them. Same thing with residential leases. If you have any investors right now selling because they're making a ton of cash, make sure that they get you the residential leases for the tenants and that you're getting those over to the potential buyers. Otherwise, they will have a termination option for that. Title commitment delivery. So the title commitment has to come within 20 days. If it does not, then it's automatically extended 15 days or 3 days before closing. If you are working a local county, Collin County, Dallas County, Denton County, you should be totally fine on this. It doesn't take us 20 days. It takes us about 3, depending on the volume. In the summer, it may take 4 or 5. If you are working a county that is in the middle of nowhere, I can tell you right now, this might come into play. We have seen scenarios where title companies are 30 days out because they are so busy and there's one examiner in the whole county. So just note, if you get a listing and it's in the middle of nowhere, I would say open title prior to even getting it under contract so that we can get it working for you. I'm trying to think of some examples of ones that are kind of in the middle of nowhere. We bought some plants recently, which is nice. We're done in Henderson. So if you have anybody buying a lake house, that's in county for us now. I think we bought Hunt in Grayson. Yeah, we're buying stuff because it's becoming more prevalent. But just note, if you're in some really weird rural area, it could be a problem. So just get it working early if you can. And it probably will take you a little longer to sell some of those anyways. So you should have some time. Survey objections. This is fairly used sometimes, I would say, not always. Make sure you guys are reviewing your surveys, please. And if you don't know how to review them or if you have any questions, please call your title person. It's kind of what we do for a living. We don't go out and inspect the property, but we know how to inspect the piece of paper that shows us where all the lines are, all the building lines, things like that. I had an agent a few weeks ago. It's going to be a big debacle. Contract for a property out in Tarrant County. Thought he was buying a lot, or thought his client was buying a lot to build on, was actually buying like a 10-foot strip of land. Went all the way through the closing process, calls me and says, hey, what do I do about this? Can the title company fix it? And I'm like, well, send me all your documents that you submitted for an offer. And it was all, I mean, it was, the title company did right. You know, the title company doesn't go out and see the property. They only know what you put on the contract. And so they had put a lot number, and the survey showed that lot number, and the commitment showed that lot number, and the final deed showed that lot number, and they thought they were buying the lot beside it. And if you look at the survey, it's pretty clear. There's a strip of land up the middle, which is what they purchased, and then there's this nice corner lot right beside it, which is what they wanted. So, you know, we'll see what happens with that. I've referred them to a litigating attorney that hopefully can help them. But, you know, just make sure you're reviewing that survey closely. And if there's anything you need to object to, make sure you're doing it with the time frame that is in this contract right here, which is the blank you have. Also, if there's anything that you're wanting to use the property for in particular in terms of use or activity, you need to make sure you're putting that in the contract. What could that be? Whether you want to use something for livestock. I recently reviewed something where they were buying a piece of land to put in a like ATV park. They wanted to ride ATVs on the weekend and want to make sure there was no restrictions on that. You know, single family use, I mean, you could look at Airbnb here, which is also going to be mostly in your HOA documents, but just make sure if there's something that your buyer is wanting to use the land for, you're making a note of it in the contract so you have a termination option for that.
So do you have any suggestions for the blank right there where it says number of days?
I mean, it's after the buyer receives the commitment, the exception documents, and the survey. And so it's just a time to review. I mean, if you're representing the buyer, you want to give them as much time as they can to look at it. If you're representing the seller, you want to know probably in 3 days whether or not everything's acceptable to them. It's just one of those parts of the contract that you get to negotiate. And so you're kind of trying to push depending on what side you're on. HOA addendum. This is probably one of my least favorite parts of the contract because I think it's when they rewrote it, they kind of wrote it kind of confusing, at least in terms of what 3 and 4 mean. And we'll talk about that in a second. Number 1 says within blank dates, seller shall obtain and pay for. Number 2 says within blank dates, buyer shall obtain and pay for. Both of these paragraphs give you a 3-day period to review. After the buyer receives, they have 3 days to review the HOA documents to get out of the contract. Okay. This is important because I've seen buyers pay over list price, waive the appraisal so that you think you have a real solid contract, and then use HOA addendum review to get out. So it's become more so a tactic than I would say what it was made for, which is so that you know what you can and can't do with your house in a subdivision. I think buyers agents are using this kind of as an additional negotiation tool to try to give you what you want to get the offer accepted and still have an out on the back end. So if you're the listing agent, just make sure your client knows we still have to get through a couple more things, even past appraisal, this being one of them. And if you're the buyer, you know, you can use this if you want, depending on how you feel about that. 3 and 4, so this is the other half of the HOA addendum. I think it's interesting. These two paragraphs kind of mirror each other, and they say, look, buyers already got the HOA stuff. We don't want an updated resale. or buyer does not require the delivery of subdivision information at all. What is important about this is that if you're getting title insurance, we will always require an updated resale certificate. We actually, as part of our title insurance, ensure that there's no outstanding HOA dues or things like that. And so we won't just take the seller's word for it, obviously. So we're going to require an updated resale cert. So the further down the HOA addendum, it says, if you check 3 or 4 and the title company requires it, who will pay for it? And then you would select buyer or seller. What it doesn't necessarily have is the same mirrored language above with the 3-day outs. So you have to make sure, you know, you're reading this part really carefully depending on what side you are representing. Because it says on this, if the buyer does require an updated resale search, you will get it to them within 10 days after receiving payment. But it doesn't necessarily have the review period. So it's kind of important to figure out which of the 4 you want to use and who you're representing. I don't particularly like 3 and 4 because I think it causes extreme confusion between the parties because they say, we don't want a resale cert. And then we come in and say, we have to have one. Even though that paragraph tells you that and tells you who's going to pay for it, it's still always an argument as to when we call and ask for credit card information every single time. So, you know, just know going into it, we'll require it. So to, you know, give your clients a heads up on that. This is another one that I think people don't really quite understand or look at, and this is material changes in the HOA. So say you're under contract and your HOA has a meeting and they decide to pass a special assessment to build something, that's a material change. So if your buyer's dues are going to go up substantially, or there's going to be a special assessment that they have to pay over the next 5 years, you know, this is something you have to make the buyers aware of. So if any of the subdivision information becomes untrue or material adverse changes occur, you have to notify the buyer and they can terminate based on that information. So I've seen lawsuits over this one because I don't think people really pay much attention to that. And I think sellers, for the most part, don't attend HOA meetings or care about what's going on, right? They're leaving the property, and so it's kind of out of sight, out of mind. But special assessments can cause problems in the future for everyone. So just make sure that the buyers or that the sellers know that if anything changes with their HOA, they have to make sure they let you know and you guys communicate with the buyers that information. You guys know about seller's disclosure. If you don't give it to the buyer, they can terminate. The only real addition I'll add here is just please disclose everything. I know Tyree knows, he's probably told you guys this. You know, your sellers should be filling this out on their own. You're just kind of there as a guide. You're not really telling them what to put down. You're just giving them information. They're giving them the form and kind of, you know, stepping away. But just make sure, and if you guys become aware of anything, you know, you really need to make sure you're getting out of that relationship if the seller is not going to disclose, because you're going to get dragged in the middle of the lawsuit. I can promise you, if there's something that goes wrong with that property and the sellers knew about it, you know, be ready. I actually had someone buy, and I don't practice in Oklahoma, but I have a cabin in Broken Bow, and so I'm part of a little Facebook group, and a buyer bought a property that had termite damage, not termite damage, bed bugs, which I think is crazy. They bought it as a rental for VRBO, went up there to see their brand new cabin and got attacked by bed bugs. And so now the question is, they contacted the property management company. The property management company says to them, because they will always say this, well, we've been treating that for a couple of months now. So now the argument is, did the seller know and did they not disclose, right? And Oklahoma law is a lot different than Texas, but it just always makes me think of, you know, our seller disclosure form, because that used to be the most litigated thing we ever saw in contract law. And so it's just really important, because the neighbors are going to sell you out. Everybody's going to sell you out. If there's something wrong with the house and the sellers knew, like, the buyers will find out. We're almost here. So just keep that in mind. Lender required repairs. You know, sellers are not obligated to do lender required repairs, especially if anything exceeds 5% of the sales price. Buyer can terminate and get their money back. What does that mean? This is this termite section most frequently. This is the termite section. So just keep that in mind. If the lender comes back and says these things have to be done before we'll loan on the property, the buyer can walk for that. Agreed upon repairs. I think this is an interesting paragraph. I don't know how many California buyers you guys are representing, but agents right now are representing a lot of out-of-state buyers. And so while you're negotiating repairs, when is your walkthrough done? Is it done the day before closing? I don't know what y'all's policy is, but I've seen this come up a little bit recently because, repairs aren't being done properly. And because the buyer is not here to do their own walkthrough, the agent's having to do it. And depending on the time frame they do it, or depending on if they don't do it, this could be a problem. Because the buyer does have an out under the contract to either extend the closing or terminate if the seller hasn't done the repairs. So be really careful. Tyree, what are y'all doing? How are y'all handling that?
In terms of the agreed repairs?
Well, just kind of like, are you doing the walkthroughs if your clients are out of state? Are you having people sign forms? Kind of what is your policy?
And we have to have someone there, either the buyer themselves or a family member or friend that would give them a POA, power of attorney, to be able to do that walkthrough and for those repairs. But a lot of what we've been doing, I probably shouldn't say that in front of you on this line. We don't do deed in lieu of repair. Well, you're not the lender, so we don't do like money. I'm sorry, we don't do money in lieu of repair. Yeah, so you don't care on that one as long as. But the lenders, they'll frown up to it. So we don't do money in lieu of repair. That has basically prevented a lot of contracts from being able to go through.
Mm-hmm.
What we'll do is in the section with the settlement monies towards the money towards settlement charges, we'll put that money in there, or we'll reduce the sales price by the amount. So if it's $5,000 of repairs, we either reduce the sales price, which is typically not the thing that I would advise, or suggest that they do, because sales price going down $5,000, depending on the amount of the home with these interest rates, how much did that really save them in monthly payment? Not much typically. But I will do it towards closing costs, right? Settlement charges, so they're less out of pocket at closing. And so we'll negotiate those repairs. But in terms of answering, kind of specifically answering your question, we do need someone there to represent them. We thoroughly go through the inspection report with the inspector, and we have the inspector there on site as well. And so that's always a good meeting. And we together come up with a strategy on, number one, how much it will take to do those repairs, and oftentimes we'll add a little bit to it as well, just in case, with this market, that the repairs or cost of the supplies and material or labor has gone up. And then we negotiate that in those two areas, either reducing the price or getting them less out of pocket, or getting them help from the sellers with out of pocket charges, costs and settlement charges at closing.
Yeah, I think that's a perfect way to handle it. Cash, and you guys can, be in charge of fixing whatever it is, or changing up things, or I think this is going to be, and I love the way you're handling it, having someone be there for them, because I think that's super important. I see a lot of people walking through houses right now with their phones up, right? Doing a little Zoom walkthrough, which, is work. I mean, get creative, I guess. But I can see that being a problem in terms of you guys have negotiated some repairs, and then you're going to make sure it's done before closing. You're doing your walkthrough with your cell phone, and people can't tell what has and hasn't been done. So I think that's a great way of approaching it. And cash is always better, I think, than trying to get somebody, especially trying to find somebody to do repairs right now is a whole nother situation. So just give them the cash, right? I love it. Okay, cool.
You always hear that happen when they try to do the FaceTime, try to do Zoom. You try to catch as many items that are in need of repair when they're doing it remotely. Right there in California, we're here and we're trying to do just a FaceTime, and they're like, "Well, I didn't, once the home closes or once they come to the final the walkthrough before closing." Like, man, I didn't know that cabinets had a scratch on it. You didn't show me, or I didn't know that this tile had this, and so now it comes back on us. So I would encourage everyone, on our team to make sure that they have, typically when they move here, they have someone here, either it's a colleague, a peer, a family member, a friend, that can actually show up at the that walkthrough with the inspector with us. And so that helps. Even if we don't get a full power of attorney, I have them sign that repair document.
Yeah, it's super important. And this one's closing date. So, this one's kind of, I wouldn't say used as much on the buy side as it is the sell side. But note that if the seller doesn't close or cure within a reasonable time frame, which makes me laugh because it depends on the judge. The buyer has two options. They may sue for specific performance, which I think you actually would have a pretty good chance of getting right now, just because housing is so short available. And I think that a judge would be more apt to give you this, or terminate your contract and receive your earnest money back. When you sign a termination of contract and you receive your earnest money, just note that is the final release for all the things. So if you would, you know, I don't think people understand that. They'll call me and they'll go, hey, we terminated the contract. We got our earnest money back. Now we want to sue for damages. I'm like, nope, you just released everybody from the contract. So just make sure, you know, you're advising your clients properly and they're talking to a real estate attorney if it gets to that level. Like I said, on the buy side, right now I'm seeing more so sellers having problems with this. Buyers changing their minds, not wanting to go through, getting cold feet about what they're paying, that kind of thing. But just know if a seller is in default and refuses to sign, you can get specific performance, or you can terminate the contract and receive your earnest money back. This is a new fun one. Have you guys talked about the new PID form?
No, we have not.
Okay. Actually, it's really important. And the more I read about it and the more I look at it and the more I talk to people, it's like becoming just it's a really big change that I think that, you know, TAR and TREC have done an okay job of communicating, but I think it can start affecting us pretty heavily up here. Okay, so MUDs and PIDs, that's a whole nother topic if you want to go into the details and the differences in the two. But just note that if you have a property in a MUD, and there's a website that will tell you that, there's a website, and I can send it to you guys because I have it all pulled up on my computer, but I'm using George's. There's a website where you can search by property address to see if your property is in a MUD. Your sellers should know if it's in a MUD because it's on their tax bill, but sometimes they don't pay attention. I don't know why I'm crazy about that stuff, but sometimes they don't pay attention. The buyer has to be notified prior to entering the sales contracts. Okay, so you don't want to get in a situation where we're getting the tax cert back with our title work, which right now is pretty quick, but you don't want to get in a situation where you don't tell them, they get the tax cert back, they see this huge MUD tax on there, and then they terminate, because now you've wasted your client's time, you've gotten kind of down the road. The actual website itself will give you all the information for the MUD, and the MUD itself can give you a notice form. So you literally just call the MUD and say, hey, we're selling this property and we need the notice form for the buyer. Boom, boom, super easy. We have a standard template, but you have to fill it all out. I would say just call the MUD. It's a lot easier because they can give you exactly the numbers versus you taking our template and trying to find them yourself. You don't want to do that. So I would say just call the MUD. And like I said, the website's super easy to navigate. You know, you should be asking your sellers as part of that anyways, but it's as a second check. The website's really fairly easy to navigate. Now, PID, they are creating a website. So this law came into effect September 1st. If a property is located in a PID, you must provide notice to the buyers at the execution time of the contract, or you can do it as an addendum. And there is an actual form that TAR has put out talking about what the notice needs to look like. And it gives it to you. You might as well use it. It's a form. You guys probably have in .loop or whatever. I don't know if .loop's right. .loop, yeah. Okay. Each PID is going to be required to file and maintain a service plan with the county clerk, but they're not all in there yet. So basically they have to file when they renew. And so we're not quite to a year. By the end of this year, everybody should be in that. If not, you're going to have to do a little bit of homework. And so there is a new PID notice form called Addendum containing notice of obligation to pay improvement district assessment. Okay, and that's the form you need to use. There's this really good legal memo that TAR put out, and it tells you exactly how to fill out the notice and what can happen if you don't. There are some exemptions that kind of, I would say they mirror the seller's disclosure exemptions. Trustees of a sale, bankruptcies, things like that, they don't have to provide this notice because they don't have the information. But most of your sellers are going to have to provide this notice if there is a PID. And the penalties include terminating the contract anytime prior to closing, filing a lawsuit after closing if they find out about it, if they close. If you do notify them prior to closing, they close and they can't turn around and sue you. But if you don't notify them, they can sue you after closing, and they can sue you for all the costs related to the purchase of the property. It's a big deal. And then you would get the property back. So basically you'd undo the whole entire transaction. You get all your cash back as a buyer, and then the seller would take the property back and have to resell it. So
Wow, that's pretty big.
it
That's
is
huge.
big. And I don't think we're talking about it enough because it doesn't always apply. So it's kind of one of those things like, well, I'll deal with it if I see it. But just know, you know, it can make a pretty big difference. And the developments that are going on up north are going to increase, I believe, the number of times we're going to have to use muds and PIDs. So
That is so true. That is
you
so
know,
true.
we need to be understanding that this was a big change in September, and it may not affect, I mean, we're in Frisco, we're selling houses in Plano and Frisco all day. Like, okay, well, when you start selling some stuff up further north, Anna, Melissa, there's some in Grayson, Green. I mean, you know, just as the developments go further north, this is going to become more crucial to know. So make sure you're asking your sellers, are you in a PID? You need to be asking that question because it's a requirement that we notify our buyers. And why? They want to basically just make sure that they know what they're buying. And so they want to give them an out to completely undo the whole entire transaction if not. And the form is fairly easy to use. You have to fill out the property address, obviously the name of the PID, the name of the municipality, and then the statute that the PID was created under. Okay, and this form, this legal memo that TAR put out gives you kind of the information on how to find that. It's fairly easy. Your MLS is a good place to start to see if you have a PID by searching for your property address. Look under taxing jurisdiction tab for your specific property because it comes from the county records. So not all the CADs, but most will show if it's in PID. And if not, you want to do a little bit more digging just to make sure, you know, if it's a new home, the builder could probably tell you if it's in PID. And then finally, you know, your tax bill will show it as well. And so you just need to be asking the sellers, what are we, you know, are you in a PID or a MUD? Because we need to make sure we're making special concessions for that.
This is
once
great.
the- Go ahead.
Sorry about that. This is great. We'd love to get that website. That'll
Sure.
help
Yeah,
our
absolutely.
entire team.
I'm going to
Thank
send
you.
this. So George is recording this. I'm going to send him or he'll have the recording on his computer. I'll send him kind of all these documents I'm referencing too, so you guys have a copy of it.
That is awesome. Thanks so much.
Absolutely. And there is some limit of liability. If you do provide a notice, it's not 100% correct. You're not going to get sued as long as it wasn't done intentionally. And we're also entitled as sellers, title companies, brokers, and any attorneys you have involved to rely on the service plan that was filed by the county. So once all this stuff is available online, it should work similarly to the way the MUDs work, where you can get all the information you need. But there's a gap period because it's not all in there yet. So just make sure you're asking the right questions, because you don't want to get stuck holding the bag and having to undo a whole entire transaction, because it's crazy to me. So keep that in mind. But I think that was the last one I added. How should a buyer terminate? Obviously in writing, not verbally. And make sure you're delivering it directly to the seller and the seller's realtor if you have that information. If not, the seller's realtor will work. But make sure you're putting it in an email and just a way that you can prove that you delivered it. And use the proper form. Don't just type in an email, we are terminating. Use the contract form. Because it covers how the reason for your termination and then any instructions for the release of your earnest money. And then this just talks about how to do it. If you guys terminate a deal, you know, we will provide that copy of the demand to the other party. If we do not hear from them within 15 days, we can release earnest money. If we hear from them that they are asking for earnest money, we have to hold the funds until we have an agreed upon release or a court order. So that's part of the escrow duties, is that we won't release money to anyone unless we have some sort of agreement or a court order. And then if you do wrongfully withhold the, you know, earnest money, you can be subject to damages. So keep that in mind. And then just as a bonus, you know that the sellers have a right to terminate now under the contract, which is brand new. And that is if the earnest money is not delivered 3 days after the effective date. So, and time is now of the essence for this paragraph. It used to not be that way, which caused a lot of problems because people would just not bring their earnest money, or they'd bring it a week later. And was just a mess. And so finally Trek fixed that and said sellers can terminate and put the house back on the market, which is nice. And that's all I got. What questions do y'all have? Oh yeah, chapel. Cool.
Do you have more information about the PIDs and the MUDs? Because I know the PID thing is, it's a lot.
Yes, I'm gonna send you guys all the websites I was just referencing. And then eventually I'm gonna put a MUDs, PIDs, and PUDs class together. I just haven't done it because quite frankly, I hate the topic, if I'm being honest. But like I said, it's just becoming so much more prevalent now. I think we need to really start digging into what the differences are and what it requires. It just it hasn't been a big deal for so long. It's like, you don't want to go down and teach that in, Plano, Frisco, Dallas, where they're like, what is this? But now we're starting to see it so much. I mean, even Salina and yeah, Prosper and yeah. Well, when you enter, if you go to the MUD website, which I'll send you, and you enter, you just, I guess, take the map to where you're at, you can see it's like in red all over where they are, and you can see them popping up quite a bit up north. And so it's like, oh, okay, this is gonna be a lot more relevant in the future. So yes, I will send you guys all of that information, and maybe we'll do a class on MUDs and PIDs and PUDs and. Sure, you guys can be my guinea pig on the class.
I really appreciate that.
Absolutely, yeah, absolutely. What other questions y'all have? Hey, come on in. Good, how are you? Oh, good. Yeah, you are.
I'm not like super COVID free. I'm like,
I'll give you hugs. I don't know. Absolutely.
The one I had was on the lender repairs. Can you maybe elaborate on that? Because in the contract, it doesn't really have much in detail on what lender repairs may look like, and that was preventing closing.
Yeah.
Or that you can pull out.
Yeah. So, so the biggest one I think that we see a lot is termite with VAs. Because that's an additional part of which I think is kind of weird, but that's an additional part of the contract, the VA termination for termites. We have seen lender like any of these hailstorms. These major hailstorms have caused us to have some delays in closing because the lender wants that fixed, and they will want to go do a re-inspection of the property, right, which we've seen happen recently. The freeze was another major one last February. We had our February was insane because we were closed for a while. And then we had all of our February closings pushed because the lenders wanted everything re-inspected to make sure there wasn't major pipe damage that they were about to loan on. Absolutely. And then all of a sudden, March was just crazy at the end of it because it was like they got their insurance money or whatever and they got all the stuff fixed and then everybody was ready to go. Yeah, exactly. So it was February was a very weird month for us last year, and then March because of it. So those are kind of the situations you're going to see, structural stuff, major stuff. And then as a result of any major damages, the tornado that wiped out Walnut Hill a couple of years ago was another big one. Houston, Harvey, right? We have title companies down there and they were losing $1 million a day down there because nobody closed, because of the flooding. And then the lenders wanted to make sure that the properties they were closing on were affected. So then they had to send people out and appraisers and, get it re-inspected and all that. So, your tick-tacky stuff is not going to be a lender required repair. It's going to be major stuff, major structural stuff that comes up.
So I just listed a home, right? In McKinney, you guys, it has you listed as the lawyer's title as a title. And as on my way here, I get a text message from the buyer's agent that submitted probably one of the top 2 offers. And we had 6 offers on it, but this is one of the top 2. They went well over list price. And then the buyer's agent said, hey, Tyree, and she's a friend of mine. She's like, hey, do you mind sending me the inspection report, the previous inspection report when they actually purchased it? No.
Yeah.
Like, why would I? No.
Why would I do that? You get your own inspector.
But I think they would send that to the lender to give themselves a potential out, especially when they waived everything else. They waived the appraisal. There's no the financial contingency, any of that kind of stuff. They waived all of it. And so it looks like a really solid competitive offer. And then if I were to make the mistake and send that to them, it bullet holes. Yeah, there's so many outs, but the biggest out is going to be that lender. Because I'm certain that if it came to it and they really want to pull out and I sent them that inspection report, then they can just send that to the lender and the lender's like, no, we can't lend based on the roof or whatever. There's
Yeah.
hit over McKinney just a few years ago, and I'm sure that that roof was not repaired since then, and so they could probably use something like that as a knife.
Oh, but it's been repaired in the last 3 years, so.
Yeah. Yeah, you have to be careful. I mean, and lenders, I've seen lenders burn their reputation doing that stuff too, like giving people outs when they, I'm like, don't do that.
Yeah.
It's going to come back to you so bad because, it is such a tiny market. It is, but it isn't. We see so many new agents coming in, but like you run across the same people so often, like don't burn a bridge and don't have a bad relationship because you're going to be on the other end of it.
Yeah.
I promise you.
I was saying back, I said, come on, I can't do that. But smile face,
Yeah.
she just sits a chuckling, like,
Yeah, just like, dang it, busted.
Like, that's right.
That's right. Well, that's what I say about the HOA addendum. I think, they're using that kind of as a tricky little, like, they don't care that you can't put an orange or a green front door or whatever, bright orange front door. Like, they don't care. They're just using that as like, we'll overpay, see where the appraisal falls, give you a waiver. And then we have all these other things.
Wow.
Yep. So,
You guys seeing some of that come into play?
I've seen it.
Especially in this market.
Yeah.
Where people,
Because people are giving you your appraisal waiver because you have to have it to win.
Yeah, that's even to get the game, right?
Yeah. To even be on the table, you have to have an appraisal waiver, and then they're using kind of the back end stuff to.
Or you see partial up to a certain time.
A few here and there, yeah.
They still aren't really good.
They're not even in the. I mean, that's a problem. They're not even. You can do it, but you're not
You
gonna.
just wasted time.
And I can't believe.
Some of the offer.
Yeah.
That you see from-
150 over
Yeah.
cash. Not even winning sometimes.
It's crazy.
Wow.
Yeah. It's getting worse.
Yeah. Well, we have so much cash coming into DFW from other areas, and it's killing first-time home buyers. That's just is what it is. It's good and bad, but it's these poor first-time home buyers that used to be able to get into a nice house for $250 and normal offer 5% down, whatever.
Yeah.
It's not that way anymore. And then you can't even get apartments. I mean, renting is just as hard. You can't find a rental home. You're having to move into an apartment. Like it's just I feel bad for the young kids getting in the market.
I'm seeing more Airbnb or room rentals, right? Where people have a home and they're renting out.
Yes, right.
rooms within their home.
That's right.
I'm seeing a lot of that. If you look on
House hacking.
Yeah.
Oh, I wish I'd have followed the house hack before. Getting married, having kids, going and living in buying a duplex and living in one side of it. I mean, that would have why didn't I do those things? I just
maybe on the outskirts, go up towards Denison.
Yeah, but I'm not going to take an owner occupied loan there because I'm not going to go live in it. That's a problem. Now you're in an investment loan where it's 25% down, and duplexes are usually 25%. It's a little different, but thinking now, I'm telling these 20-year-olds and I'm like, go buy yourself a duplex, or you can use the traditional loan, even a fourplex. You can use your traditional loan and get in.
Military. We'll get some of the military benefit, and he's wanting to take the money that they're giving him and put it in crypto. I'm like, please.
Don't do it. Don't do it.
Dump it in. You get a $40,000. It's a loan still. They have to pay it back. They give them years of no interest on it, right? He just dumped all his money in crypto. I'm like,
I mean, it may work out great, may not. I don't know.
I know one thing that probably would work out very well is less likelihood of it. There's a good potential success rate, and that is real estate.
Real estate, absolutely. It's the asset that always appreciates.
Yep. The real estate here, even more so.
That's right.
I mean, let's leverage this time and location.
That's right.
Like there's a semiconductor plant coming in Sherman.
I know.
That's going to drive close to 10,000 jobs to Sherman and the Denison area. Why not?
We're looking at a new build duplex in Denison to buy for that reason.
Yeah.
Because you can still get them relatively affordable.
blowing up out there.
If you don't mind.
If we don't buy it, I'll send it to you.
There might be more, right?
Oh, yeah. No, he's a builder up there. He just put, I think he put 3 in and 2 of them are bought. We'll see.
There's a monument agent maybe about a year ago that we were talking with, and he bought a house, decided to live out of the garage and rent out the main living space.
Oh,
Wow.
Wow.
That's
He
dedication.
was like 18.
That would stress me out. I'm like, I gotta have the wall, like the duplex I could do, not the,
At 18,
Not the
you don't care about
garage.
too much.
at 18, I mean, that's true. Where I was living in college, not any better than a garage. So. All right, well, I'm gonna stop this recording unless anybody else has any questions. Yeah, of course.